This morning, the U.S. Supreme Court heard oral arguments on whether or not Tennessee's Senate Bill 1 violates the Equal Protection Clause of the Constitution's 14th Amendment. The law, which protects minors from so-called gender transition procedures, is similar to those passed in nearly half the states in the nation. And by most accounts, the Supreme Court's conservative justices appear likely to side with the state of Tennessee. Joining me now to discuss this is the Attorney General of Alabama, Steve Marshall, who is among those leading the charge against the Biden administration's push for irreversible mutilation of children. He filed an amicus brief in the Supreme Court case and was at the court today in support of Tennessee's law. General Marshall, welcome back to Washington Watch. Thanks so much for joining us.
Good to be here, Tony. It seems like we continue to talk about this issue, but it gets better every time.
Well, finally, it appears that the tide is turning as the facts are coming out. But I want to first get your thoughts, your general thoughts on how the arguments went today and where the justices may be leaning.
Yeah, I think the Solicitor General for Tennessee did an outstanding job in being able to truly eviscerate the argument that was being made by both the Department of Justice and the ACLU that this was somehow or another a law passed by the state of Tennessee that dealt with gender and that discriminated based upon one sex. And that's not at all what Tennessee has done. What they've done is be able to outlaw a procedure that creates experimental treatment on kids with tremendously adverse effects. And so I was very pleased by the questioning that we saw from the court, particularly the aggressive pushback from Justice Alito when the Department of Justice truly misstated the facts as it relates to how accepted this type of treatment is and what the potential consequences are for kids long term. And so I feel confident that Tennessee will prevail and gives an opportunity not only for Tennessee to be able to continue this protection, but also the countless other states across the country that likewise want to be able to protect our kids.
So speaking of that, General Marshall, will this case have implications for these other states? I think in total we have 26 states that have similar laws.
I think it will, only as it relates to the legal standard that will be used to evaluate the particular state statutes. For example, when the court rules in this case, we'll have an opportunity to be able to present what the court has done to our district judge to be able to establish why Alabama clearly has a rational basis to be able to protect our children and to use that from the court's perspective to determine whether or not the statute itself is lawful. But, Tony, I would say that even if the court were to rule with the plaintiffs and to say that there's a higher level of scrutiny that needs to occur, I believe the medical evidence is so strong that states are going to be able to meet that standard as well.
Did that come forth in today's hearing?
Sadly not, only because, the Tennessee case is relatively new from a litigation side, whereas Alabama's, we have a much more robust development of the underlying facts. And you and I have discussed previously about the absolute fraud that's taken place on parents and children across the country as we see this coalition of social justice lawyers, the Biden administration through Admiral Levine, influencing medical professionals and developing standards of care, not for what's best for kids, but instead to advance their own political agenda. And clearly that's not right. I don't think anybody can accept this idea that medical practice ought to be dictated by your political philosophy and not what's in the best interest of children. And so very comfortable that we're going to be able to develop that for all of the states to be able to use. I think when judges have an opportunity to hear it, as recently they did in the state of Missouri, that we're going to find compelling orders supporting this idea of protecting our children.
It would appear, General Marshall, that as the facts have been coming out, in not just in the courtrooms, but in dialogues like this one, and as you've had to defend the law there in Alabama, and as legislators have taken up this issue, taken testimony, and what we see internationally, as many foreign countries are backing away from these radical positions, it appears that the public opinion on this has shifted quite significantly in the last 5 years.
No, I think absolutely. And when Alabama first passed its law, it was only one of 3 states to have done so. And candidly, it was with great opposition from many that felt like that we were not doing what we needed to do to be able to help kids deal with gender dysphoria or gender incongruence. But yet what we've learned, and particularly with the development in Europe, and who would have thought that we'd be looking to Europe to be able to support these ideas, But when they engage in that systemic review of the literature, they found little to no evidence that these treatments, in fact, help kids and saw significant risk, both short-term and long-term, when kids undergo puberty blockers, cross-sex hormones, and more particularly surgeries. And all we've seen over these last 5 years is a continued push from the literature and others that have had a chance to view this in an unbiased way, is to say this is not the direction that we need to be teaching kids or at least treating kids that suffer from these conditions.
General Marshall, you have tracked the court for some time, and the court has a propensity to surprise in its opinions that it releases. So while the questioning and the comments may be leading toward a support of the Tennessee law in this case, what are some of the possible outcomes? Because sometimes they can sidestep some of the issues. What might be some of the possible outcomes when the court rules on this, probably near the end of June of this next summer?
Well, one thing that Justice Alito did, I think, a fabulous job today was to really push back on the remedy that was being sought by the petitioners in this case, so that they very much narrowed the scope of what they were asking. So to the extent that you were looking for worst case scenarios, it would be that this court would come down and accept this idea that there is a heightened level of scrutiny that needs to be placed on laws of this type. They wouldn't be deciding whether or not Tennessee's law was in fact valid or invalid, but instead would just simply say that we will embrace this idea that this is a gender-specific law for which the state has to meet a higher burden of proof. But as we were able to establish in our 11th Circuit in a concurring opinion issued by Judge Brasher, he believes that even if it's a heightened level of scrutiny, the evidence is so compelling, the facts are so strong, and that we would be able to meet that burden as well. And so I remain confident, regardless of the result of this decision, that states will be in a good position. But I truly believe that we'll have a 6-3 or 5-4 decision supporting the efforts of Tennessee and validating the ruling they received from the Sixth Circuit.
In your opinion, did the opponents of this law, did they establish anything in today's oral arguments?
I don't think they did. In fact, their greatest advocates were coming from the bench, whether it be Justice Sotomayor or Justice Jackson. They advanced more of the argument than we heard from either of the two advocates. But that shouldn't surprise us, correct? I mean, those are individuals that we did not expect necessarily to be in favor of the Tennessee law. In fact, they dissented when the court had on its shadow docket a question involving Idaho for reasons very similar to they expressed today. But I think that the law itself, as Tennessee was able to present today, is very compelling for the court to be able to use the rational basis review. And I think that's the conclusion the court's going to ultimately reach.
If I read this correctly, one of the attorneys that was opposing the law for the ACLU was a transgender attorney, setting kind of a historical record, being the first transgender to argue before the Supreme Court. Is this more of the identity politics that they were hoping to use to bolster their case?
Well, I think absolutely, Tony. This is an advocate that went in a TV interview the day before his argument and said that his 2-year-old can make a decision about whether or not to change their gender. Obviously, that's not what Americans believe. It shows that this is more political than it is legal, and we need to do right by our kids to make sure that those who are suffering from gender dysphoria have the right type of treatment, but we don't want them to be experiments that harm them for the rest of their lives.
Yeah, this is something that we will look back on, I think, in years from now. Hopefully we'll look back knowing we got it right. General Marshall, always great to see you. Thanks so much for stopping in today and joining us.
Thank you.